Tampering with evidence. Basically, we have a set of laws that deal with, two types of tamperers. One would be if law enforcement tampers with evidence, and then the other would be if a suspect, a arrestee, a defendant tampers with evidence. A defendant that tampers with evidence, there's two types of evidence. You've got witnesses and you've got physical or tangible evidence. We have laws that address both. Anybody that attempts to intimidate a witness or interfere with a witness participating in an investigation or testifying at a trial is committing a felony. Very serious felony at that. Anyone who tampers with physical evidence is committing the crime of obstruction of justice. It gets a little bit tricky because one of the elements that a prosecutor must prove is that I knew that a criminal investigation was underway or was certainly going to be underway. But if a prosecutor can prove that a person destroyed evidence knowing or having reason to know that a criminal investigation was going to begin, we've got a violation of obstruction of justice. There's also a specific law that prohibits peace officers or police officers, law enforcement, from tampering with evidence. They're not charged under the obstruction of law statute. They would be charged with a particular statute that deals specifically with law enforcement who would tamper with evidence. If we get into a situation where we have like a crime lab technician or someone who deals with evidence that makes its way into the criminal justice system, but isn't a peace officer, they would fall under the obstruction of justice statute and be prosecuted under that law.